Good afternoon and welcome. I'm Catherine Fitzgerald Wyatt, the Education and Outreach Manager here at the Library of Virginia. And I'm very pleased to welcome Richard Rothstein, who will be discussing his books, The Color of Law, A Forgotten History of How Our Government Segregated America, and Just Action, How to Challenge Segregation Enacted Under the Color of Law. Rothstein is a distinguished fellow of the Economic Policy Institute and senior fellow emeritus of the Thurgood Marshall Institute of the NAACP Legal Defense Fund. He is the author of many other articles and books on race and education, which can be found on his webpage at the Economic Policy Institute. This event is part of the library's programming related to our exhibition, House to Highway, Reclaiming a Community History, which is on view at the Library of Virginia until February 28th. And without further ado, I will turn this over to Richard Rothstein. Thank you.
Thank you very much, Catherine. Thanks to all of you for the interest you've shown in this topic and for engaging with me today. I wrote a book, The Color of Law. Some of you may have read it. It describes the history of how government policy segregated America. I got into this kind of accidentally in the 1990s, early 2000s, 1980s actually. I was an education policy writer, a journalist. I was the national education columnist at the New York Times. I was the education policy analyst at a think tank in Washington. And so I was following education policy fairly carefully. And in 2007, I read a Supreme Court decision that evaluated two school district policies, one Seattle, Washington, the other Louisville, Kentucky. Both of those school districts had segregated schools, as do most school districts in this country. And the school districts wanted to do something about the segregation. And so they both enacted a very trivial, small program, a choice program that allowed parents to choose which schools in the district they would like their child to attend. And if the parent's choice was going to exacerbate the segregation of the school, that is, it was a majority white or a majority black school, and they were of that same race, that choice wouldn't be honored if there was another parent wanting to attend that school who would wanting her child to attend that school, who would help to desegregate the school. Very, very limited program. You would have to have a very few places left to have to make a choice between two different applicants. But nonetheless, opponents of this program sued, and the Supreme Court evaluated it. The opinion was written by Chief Justice John Roberts. As I said, I was an education policy analyst, so I read it very carefully. He prohibited the school districts from continuing with this desegregation program. His reasoning was that, yes, he said, the schools in Louisville and Seattle are segregated, no question about that. But he said they're segregated because the neighborhoods in which they're located are segregated. He was right about that as well. And then he went on to explain that the reason the neighborhoods were segregated was because of purely private activity. Maybe homeowners or landlords who didn't want to sell a home or rent a home to an African American in a white neighborhood. Or maybe it was because of private businesses that were discriminating in how they carried out their purely private sector activities. Or maybe it was just because people like to live with each other in the same race. That's why we're segregated. Chief Justice Roberts said that all of these are the reasons that we have segregated neighborhoods. And he said what happened by private activity can only unhappen by private activity. It's not the role of government to undo people's private choices. He called the system that we had de facto segregation, and de facto segregation meaning that it just happened in fact, but not by law or by public policy. Well, I read this decision and I recalled two different things from my own past reading and background. One was I had read a book some years before called The Wall Between, which described the effort of a white homeowner in a single family home in an all white suburb of Louisville, Kentucky, one of the districts involved in this case. Uh, he had an African American friend living in the center city of Louisville. Uh, the African American friend had a wife, a child, wanted to move to a single family home, but no realtor would sell him one. So the white homeowner in this suburb of Shively um, bought a second home in his community and then resold it to his African American friend. And when the African American family moved in, a mob of about 300 white neighbors surrounded the home, threw rocks through the windows, dynamited the home. The police protected the mob, did nothing to try to interfere with them. But when this riot was all over, the state of Kentucky arrested, tried, convicted, and jailed with a 15-year sentence the white homeowner for sedition, for having provoked a riot by selling a home in a white neighborhood to a black family. And I remembered this book that I had read, and I said to myself, this doesn't sound to me like de facto segregation. The police, the courts, the prosecutors, the prisoners, the prisons, these are all state agencies. Uh, it's an unconstitutional action for them to promote segregation in this way, a violation of the 14th Amendment. And it may be something that John Roberts should know about. And then I thought about something else that in my own past, and when I was a very young man, uh, I'm sure before any of you were born, I was a research assistant at the Chicago Urban League in the early 1960s. And in that role, I worked on a civil rights lawsuit that challenged the fact that the Chicago Housing Authority was placing housing projects for African American families only in black neighborhoods and placing housing projects for white families in white neighborhoods. It was segregating the whole city with these public housing projects. The um, the case eventually went to the Supreme Court. The Supreme Court agreed that it was an unconstitutional system in which public housing uh, was cited, and this is another case where segregation was imposed by government policy. In this case, local policy, local government policy, when the housing authority cited where public housing projects should be built. Well, I didn't know at that time. I was one who used the term de facto segregation, as did most people I knew. I didn't know anything more about this history, and I wondered, though, whether these two things, the use of state violence, state-sponsored and protected violence to reinforce racial boundaries, or the actions of public housing authorities to segregate a city with its projects, if these were just unusual situations or if they were more um, systematic. And I began to look into it further. I spent about 10 years from the time I began looking at it until the time The Color of Law was published. I didn't know much about housing at that time or about residential segregation, uh, but I learned a lot. I I'm not a an academic researcher. What I did was started with books that had been published previously, mostly by academics, and just traced all of the source notes that they used in these books in order to create the history that I wrote about. And of course, pretty soon I realized that the Chicago Housing Authority's actions and the actions of the Louisville police and criminal justice system were not unusual. They were not unique. In fact, they were representative of what happened everywhere in the country. Well, let me take just a few minutes to describe some of the more powerful policies that government imposed. And those of you who have read The Color of Law, I apologize for repeating myself, but I think the story needs to be told again. Some of the more powerful policies that the federal government implemented in order to create a segregated society. In the 40s, late 40s, early 50s, there were millions of World War II veterans returning home after the war, needing housing. We had a housing shortage at the time. Uh, it was illegal, actually, during World War II to use construction materials for civilian purposes. It was all directed to the war effort. Prior to World War II, we were in a depression, and so very little housing was being built. So there was an enormous housing shortage that these returning war veterans were uh, confronting when they returned home. In addition, we are at the time an urban society. The only people living in suburbs at this time were the very rich, and not very many of them. Uh, we were a manufacturing economy. Factories needed to be located near deep ports and railroad terminals to get their parts and ship their final products. And so the workers in those factories, both African Americans and whites, as well as the middle class workers or the white collar workers in the banks and the insurance companies and other service industries that were serving those factories, they all had to live close enough to those factories in the downtown areas to be able to get to work easily. Most of them didn't have automobiles. They maybe walked to work, took short streetcar rides. Uh, so we were a manufacturing economy and an urban society. The federal government began a program to create housing for those returning war veterans, and in addition, to move all those existing households, white households living in those urban areas, move them into single-family home suburbs outside the city limits, and prohibit African Americans from doing so. This was a racially explicit program of the federal government to create a much worse segregation than had existed previously. The example I used in The Color of Law, and some of you may recall it, it was a suburb east of New York City called Levittown. It was actually one of the largest of these suburbs that were built, but they were built everywhere in the country with federal government control. They had federal government control because the builders, like William Levitt, who built Levittown, couldn't find banks that would lend them the money to buy the land or build the project. The banks thought it was a crazy idea to think that people were going to move out to these suburbs. And so they wouldn't lend Levitt or any of the others the money. The only way Levitt could build this enormous project, Levittown, was by going to the Federal Housing Administration and Veterans Administrations, two federal agencies, submitting his plans for the project, the materials he was going to use to construct it, the layout of the streets, the architectural design, and a commitment required by the Federal Housing Administration and Veterans Administration never to sell a home to an African American. These two agencies even required Levitt and many of the other developers around the country to place a clause in the deed of every home prohibiting resale to African Americans and rental to African Americans. This was a federal policy. It wasn't the action of rogue bureaucrats. These weren't just ideas that bigoted federal officials came up with. It was written in a federal policy manual that was distributed to appraisers all over the country, whose job it was to evaluate the applications of developers to build these single-family homes in suburbs. The manual said that you couldn't recommend for a federal bank guarantee a loan to a developer who was going to sell homes to African Americans in a white neighborhood. You couldn't even recommend for a federal bank guarantee a loan to a developer who was going to build an all-white project that was going to be located near where African Americans were living. Because in the words of the federal policy manual, that would run the risk of infiltration by inharmonious racial groups. That's a quote from the federal policy manual. This notion of de facto segregation is utter nonsense. This policy was probably the most powerful policy in creating the rigid segregation that we know today. The homes at the time that we were building for returning war veterans and people moving out of the white people moving out of the cities with federal subsidies, they were modest homes, 2-bedroom, 1-bath homes typically. They sold at the time in the late 1940s, early 1950s for around $9,000 a piece. In today's money, that's about $100,000, a bit more than $100,000 uh, for these homes. But these $100,000 homes, as you know, no longer sell for only $100,000. In every community in the country, every metropolitan area in the country, they sell for $200,000, $300,000, $400,000, $500,000. Some places $1 million or $2 million for these $100,000 homes. The white families who were subsidized by the federal government to move into these homes did not expect to get rich by this process. They needed housing. They were desperate for housing. Nobody expected these homes to appreciate in value the way they did, but they did appreciate in value. And the white families who happened to be lucky enough to benefit from this subsidized program of the federal government on a racial basis gained wealth as a result of that appreciation. They used their wealth to send their children to college. They used it perhaps to take care of temporary emergencies, maybe a short-term unemployment or maybe a medical situation. They used it to subsidize their retirements, to supplement their Social Security. And they used it to bequeath wealth to their children and grandchildren, who then had down payments for their own homes. African Americans were prohibited by explicit federal policy from participating in this program that generated wealth for white families, but not for them. Today, nationwide, African American families have incomes that on average are about 60% of white family incomes. That's a significant disparity. There are causes for that as well. I'm not going to discuss them today. But you would think if there was a 60% income ratio, there should be a 60% wealth ratio as well. People can save the same amount of money from the same incomes. But the reality is that while the income ratio is 60%, the wealth ratio is about 10%. African Americans have average income 60% of whites, but average household wealth about 10% of white wealth. That enormous disparity between a 60% income ratio and a 10% health wealth ratio is entirely attributable to unconstitutional federal housing policy that has never been remedied, and that all of us as Americans have an obligation to remedy. Constitutional violations impose on us an obligation to remedy them. They can't simply be ignored if we take our responsibilities as citizens seriously. So the wealth gap that we created locked in the segregation that this program created because African Americans, increasingly because of a lack of wealth and because of the appreciation and the value of these white neighborhoods, could no longer afford to move out of low-income Black neighborhoods that frequently caused enormous harm, more polluted because they were located near industrial areas, schools that were less well funded, even after Brown versus Board of Education, a neighborhood where there were no grocery stores selling fresh and healthy food, but lots of fast food outlets. So the wealth gap that was created did enormous harm and is responsible for much of the racial inequality that we have today, not just in housing, but in health, as I just mentioned, in education, in the quality of schools and the funding of schools, certainly in the criminal justice system. When you concentrate disadvantaged young men who have no access to good jobs or the transportation to get to those jobs, you concentrate them in single neighborhoods, it's inevitable that they're going to engage in confrontations with the police who are trying to control their behavior so that their disaffection doesn't spill out into white neighborhoods. As a result, we have a mass incarceration rate among African Americans, which is among the highest in the world. Well, this is the consequence of this policy of the federal government to move white families out of urban areas into single-family suburbs, white suburbs, and prohibit African Americans from following. Well, I mentioned earlier another policy that I had personal experience with, and that's the policy of creating segregated public housing. The first public housing in this country was created in the New Deal during the Roosevelt administration. The federal government, prior to Roosevelt's election, had never before been involved in the housing market. It was a private market at that time. There had been never public housing or subsidized housing of any kind built. But in the New Deal, in one of the very first programs of the Public Works Administration, the federal government began to build public housing, not for poor people, but for middle-class families. As I mentioned earlier, there was very little construction going on. We had a big housing shortage during the Depression. So the federal government began to build public housing for working middle-class, lower middle-class families who could afford to rent apartments, but for whom no housing was available because of the housing shortage. These apartments that the federal government built initially in public housing projects in urban areas were places where the families who were housed in them, mostly white, they were mostly white families, paid the full cost of the housing and their rent. They weren't subsidized, but they were segregated. Separate projects for whites, separate projects for African Americans, frequently creating segregation where it hadn't previously existed. I described in The Color of Law, perhaps some of you remember this, I described the great African American poet, novelist, playwright, Langston Hughes. He grew up in an integrated downtown Cleveland neighborhood. When I say integrated, I don't mean every other house was a different race, but broadly, there were people you would run into on the street, different races, different ethnicities. He grew up in this neighborhood in downtown Cleveland. He writes in his autobiography that his best friend in high school was Polish. He said he dated a Jewish girl in high school. It was an integrated high school in an integrated neighborhood. The Public Works Administration, the first New Deal agency to build housing, went into that neighborhood, demolished some housing, and built two separate projects, one for whites, one for African Americans, creating segregation where it hadn't previously existed. And this was done many, many other places in the country, not only reinforcing segregation, but creating segregation where it hadn't previously existed. Once the suburbs that had been created by the Federal Housing Administration and Veterans Administrations gained in value, appreciated in value, and once the white homeowners became wealthy and the African Americans excluded from that, had no such wealth, the white homeowners in these suburbs decided to use their authority as local control to create zoning ordinances to prohibit any housing to be built that would might be accessed not only by lower income families, but by middle income families. Most of the housing in residential areas in this country is zoned for single family use only. What that means is that as the homes appreciated in value, African Americans in particular, but other middle class families had no ability to access them. They became more expensive. You couldn't build duplexes or triplexes, or I'm not talking about high-rise public housing projects. I'm talking about modest homes for working and middle-class families that belong in those neighborhoods, but you couldn't build them because of the zoning ordinances. This is a local policy that also has an unconstitutional effect because it builds upon a segregated system and then reinforces it. So this is a local policy that is also unconstitutional, violates the 14th Amendment that perpetuates segregation. Well, there were many, many other federal, state, and local policies that created the segregation we know. Well, I wrote the book, The Color of Law, and of course, let me say that I know that the reason for this meeting today is the use of the federal public housing highway system, rather, to demolish Black neighborhoods. Some of these Black neighborhoods should have been demolished and rebuilt because they were slum dwellings. uh, lack of adequate heat, lack of adequate safety, fire traps. People double, tripled up in homes because they had no place else to live. Some of them were middle class Black communities. From what limited I know about the Jackson Ward uh, neighborhood, that was substantially a middle class community, although I imagine there were many poor people as well living there in inadequate housing that should have been redeveloped. Well, the public, during the 1950s, the federal government began a program, they called it urban renewal, to demolish uh, what they called blighted neighborhoods. They were disproportionately African American. Many of them were low income. Many of them, some of them were middle income. But when they demolished these neighborhoods, allegedly to eliminate blight, they made no provision for relocation of the families who were displaced, to move them to better housing, to perhaps use their powers to break up these segregated white neighborhoods and allow displaced families to move into them. And there were many, many examples of this throughout the country where the federal highway system was explicitly designed to remove African Americans from neighborhoods near downtown areas that the rulers of these downtown, the officials of these downtown areas wanted to redevelop into middle class commercial spaces. And one of the tools they used was running the spurs from the interstate highway system into these neighborhoods frequently when they had other options. Uh, you've probably heard all of you about Santa Monica, California. Santa Monica had a middle class Black neighborhood called Sugar Hill. The federal government decided to route the Santa Monica Freeway through that neighborhood because many public officials had previously tried desperately to get African Americans to leave that neighborhood. They were too close to whites from their point of view. A local neighborhood association attempted to buy out Black families who moved in unsuccessfully. So the federal government simply routed, when it was unsuccessful in using other means to displace this middle class Black neighborhood, they simply routed the highway system through it. It turns out that just a mile or so north of it, there was a completely undeveloped area that would have been a perfectly available route for the Santa Monica Freeway. But the federal government declined to use that perfectly suitable route. Instead, chose the route that demolished housing for the residents and made no provision for their relocation. In The Color of Law, I give another such example, Miami, where a route was also chosen, where an easily available, low-cost route, abandoned railroad track right of way could have been used, and the federal government instead used it to demolish a Black neighborhood. Well, as I began to say before, I wrote this book, and the question that the people frequently asked was, well, what can we do about it now? We understand now from reading The Color of Law or listening to you talk that this was an unconstitutional system. But what can we do about it now? It's there. How can we fix this? Well, I got this question so often that I felt I had to answer it, even though I was retirement age and well past retirement age and should have had to do this. But I was fortunate enough in having a daughter who was a housing expert. And so it made writing a sequel book that explained what we can do about it now a pleasure rather than a burden. And the book is called Just Action, and it explains many, many policies and practices that can be used to redress segregation. And many of them are even possible today in this current horrific environment when remedying segregation has been declared almost illegal by the federal government. I'll give you just a couple of examples before I close of the kinds of things that could be done to remedy segregation today. It'll be small steps, not it can't be done overnight. but we should get started. The book Just Action begins by describing how we can't redress segregation unless we form groups to do it, unless we create neighborhood organizations, community groups that are committed to the cause of desegregation and begin to plan how to address it. Such groups ideally should be biracial, multi-ethnic, but the most important thing is they are composed of people who are determined to take action to redress segregation. So let me give you just a couple of examples before we turn to the question period. In 2019, a newspaper on Long Island, the newspaper's name is Newsday, a newspaper on Long Island did an investigation of real estate practices on Long Island. What they did was they sent pretend buyers to look for homes, to visit real estate agencies, and see what was available. They were black and white matched pairs. They went at different times, but with the same kinds of qualifications, the same family structure, the same educational background, the same income between the buyers, the potential buyers, and these potential buyers wore buttonhole cameras to record their interactions with real estate agents. This is a perfectly legal thing to do in almost every state. I don't know about Virginia, but I imagine it is. You can record a conversation that you are a participant in without the permission of the person you're speaking to. Well, what they found was that in 50% of the cases, 50% of the cases in Long Island, New York, African American home buyers experienced discrimination when they went to a real estate agency to try to buy a home. They were shown different homes from the white applicants. They were given different listings to look at themselves. They were given different characterizations of the neighborhoods, whether they would be happy there or not happy there. Every one of these actions, blatantly unlawful, and a violation actually of the 14th Amendment, because every real estate agent in the country, in Virginia and everywhere else, is licensed by a state real estate agent, a state licensing board. And anytime a state licensing board renews the license or gives a license to a real estate agent who discriminates, and we know that in Long Island about 50% of them do, it's violating the 14th Amendment to the Constitution. Well, what can you do about this? Well, prior to the current administration, fair housing centers, they exist in almost every community. I'm sure there's one in Richmond, although I don't know for a fact. Fair housing centers can do this kind of paired testing to uncover racial discrimination at real estate agencies. It requires funds, it requires volunteers, and they do very little of this testing because they have neither the funds or the volunteers. And any one of you could volunteer to such a fair housing center and engage in this kind of testing, paired testing of local real estate agencies. Long Island Newsday actually posted online its report of this discrimination. The videos are there as well, not behind a paywall. You can look and see for yourself what the kind of practices these real estate agents used. Well, today it's a bit more difficult. The federal government has cut the limited funding that it gave to fair housing centers, and recently the federal government has announced, or I guess in a number of different actions, that it will no longer enforce the Fair Housing Act and its prohibition on discrimination. But that doesn't mean that a local group can't enforce it. You could, if you were a member of a group that was doing this kind of pair testing, find violations, and the evidence would be clear if you have pair testing evidence, and sue as a private action, even if the federal government is no longer willing to enforce the Fair Housing Act. And you could insist that your local state licensing agency lift the licenses of real estate agents whom you discover are discriminating. The same thing is true of landlords. There's an enormous amount of discrimination against landlords, against housing applicants by landlords. The It's a lot less expensive to engage in paired testing of landlords because that can frequently be done on the phone. If if a an applicant for an apartment wants to inquire about its availability, calls up and has an obviously African American name and dialect, and a white applicant at a somewhat distant time, not too distant, calls up and finds the same apartment is available. That's good evidence of discrimination and also can be pursued um, as a matter of private action when the federal government is unwilling to pursue it. I'll give you one other example and then I'll close for questions. You're all familiar, I'm sure, with the Section 8 program. The Section 8 program, it's a subsidy to apartment dwellers. It actually stems in large part from that lawsuit that I told you I was involved in the mid 1960s about segregation in Chicago in public housing. The federal government, after it was required by the courts to cease segregating public housing projects, it basically stopped building public housing and instead started issuing vouchers to families to seek apartments in the open market by themselves if they were income eligible for public housing. The way in which the voucher system is designed makes it almost guaranteed that it will reinforce segregation because the voucher amount is calculated so that the family spending 30% of its income on rent, a household, spending 30% of its income on rent, can afford an apartment that rents for 40% of the median rental in the area of the public housing authority, which is usually a whole metropolitan area. Well, 40%, that is 10% below the median of all rents in the entire metropolitan area, is only going to make apartments available in low income, usually segregated neighborhoods. The Section 8 voucher system, as it was designed, gives families no access to apartments in better neighborhoods. Well, a lawsuit in 2000 and I forget, maybe 2018, filed by the Inclusive Communities Project of Dallas, a civil rights group, charged that this was a racially discriminatory system, the Section 8 voucher program. And as a result, the Department of Housing and Urban Development adopted a program called the Small Area Fair Market Rent System, in which a family, a household that wants to move to a higher opportunity neighborhood, one that's not polluted, one that has better schools, one that has grocery stores selling fresh food, one that is not concentrating the most disadvantaged young men without access to jobs, and that is in fact closer to good jobs. A family who wants to move to an area like that gets to a voucher that's worth 40% of the median rent in that higher opportunity community. So it holds the promise of desegregation, except it needs to be enforced. It needs people to be monitoring whether landlords discriminatorily refuse Section 8 voucher holders who have those kinds of vouchers. And that's another thing that local groups can do. So there are many, many actions described in the sequel book, Just Action, that people can use to redress segregation. I hope that some of you will be motivated to create the kinds of groups that can do that, even in this very terrifying environment that we're in now. With that, I want to thank you for your attention, and I'd be glad to answer questions for whatever time remains. Thank you.
Thank you so much. I'm giving a clap. I think we all are to Richard Rothstein. That was just fantastic. We have a lot of questions, so I'm going to try and go through things I think that you didn't address at all first. or maybe not as much as the detail of the question. So the first question is talking about Richmond specifically, in that we are currently in Richmond going through zoning code refresh that proposes to allow 2+ housing units and ADUs on every residential lot in the city. Many of the whitest, wealthiest areas are very against this, of course. What talking points would you use to help convince them that it's a positive change?
Well, the first thing I would say is that the opponents of these kinds of changes are much more vocal than the supporters. And I again go to the point I made before about forming local groups. In addition to publishing this book, Just Action, my daughter and I created a Substack column that we post at fairly often. And in one of them, she described one of these white communities in California called Menlo Park. Menlo Park had a group that had organized in the way that I described. It was called Menlo Together. They actually started as a reading group, reading The Color of Law, and so they were aware of these issues. And Menlo Park had the problem of enormous high rates of turnover among the teachers in its school district because nobody could live close enough to the places where they worked in order to be able to come to commute to school. So the school district, another thing that's fairly common, had a lot of vacant land. In part, I think, because as the community became wealthier and wealthier, the number of children declined. And so it had empty school sites and vacant land. So the school district proposed to build on some of this vacant land affordable housing that would be affordable to school district employees. A group opposed to this, as the groups that you're describing in Richmond are, immediately got signatures and filed a petition to get a prohibition on zoning change that would be required in order for the school district to do this. And the petition, the ballot initiative not only prohibited this petition, but it also this project, but also prohibited all future zoning changes without a referendum of the entire community. Well, the Menlo Together group was very unhappy about it. They thought this was a terrible thing. They were sure they were going to lose, but nonetheless, they started a campaign to try to defeat this initiative. And to their own surprise, they went around knocking on doors, talking to people. They found there were a lot of people in that community who wanted a more diverse community, wanted a community where their teachers could live and their firefighters and police officers and other people that they depend upon. And miraculously, they defeated the initiative. What they found was, despite the vocal objections like you're experiencing now, there was a majority of silent people who didn't like the idea of living in such a segregated community, such a homogenous, boring community. So I think that's one lesson you can take from it. I urge you to go read that column that she wrote in the Substack column. It's called Just Action, Substack Just Action, something like that. And I think that's something that you could do as well. But it can't be done unless you organize local groups to start to take this action. It means volunteering your time to knock on doors, to explain to people why this zoning change is a good idea, why it will make their community healthier, more diverse, and more interesting for everybody to live there.
Thank you. So we've got another question about zoning, and this one is thinking about how you would respond to people who think the opposite of exclusionary zoning is inclusionary zoning, meaning a policy that requires developers to put aside affordable units in new construction projects. This questioner says it seems like the consensus is that inclusionary zoning policies stifle new development and, in fact, don't help with desegregation.
Well, inclusionary zoning can mean a number of things. As I argue in both books, really, it is not a good idea to segregate buildings any more than it is to segregate neighborhoods. That's not healthy. We want mixed income and mixed race neighborhoods throughout this country. That should be the ideal. It'll take a long time to get there, but that should be the ideal. Inclusionary zoning that requires a share of units uh, to be reserved for moderate income and a few for low income families as well, along with a majority of market rate units, is a healthy development. Again, it should be low rises. It should be architecture that fits in with the community, and it should permit some diversity and access to the community from people who've historically been prohibited from living there. If by inclusionary zoning you mean simply providing some units for the very poor where everybody else is wealthy, that is not a healthy form. And the other thing that I think your question is asking is it makes it more expensive to develop housing. And I think that's correct. And it shouldn't be, because what the inclusionary zoning program essentially does is it cross-subsidizes. It requires a builder, if the builder wants to make the same profit, to rent or sell the market rate units at higher than he otherwise would in order to create the subsidy that permits him to sell or rent the affordable units at a lower price. But that's a function of the fact that we don't subsidize the families rather than the housing units itself. It shouldn't be the developers who bear the burden of our segregated system. It should be the community as a whole. These particular developers weren't responsible for it. But I mentioned the Section 8 program before. Only about a quarter of all Section 8 voucher holders get voucher eligible families get Section 8 vouchers. It's way underfunded. Only a quarter of them get it. There are long, long waiting lists even for Section 8 vouchers. And we should also be subsidizing middle income housing, which is unaffordable in itself in many areas of this country. I don't know if it's true in Richmond, but in many, many cities of this country, even middle class families can't afford decent housing. So we should be subsidizing the homeowners or renters, not requiring the developers to bear the burden of the subsidy. But we're not doing it. And so is a cross-subsidization by the developers a second best alternative? Yeah, it's not a good one. But until we're prepared to raise the funds to subsidize families who can't afford housing, that's what we're going to be stuck with.
Thank you. And so I've got a question, and we're sort of going back to the beginning in some sense, but I think this might be helpful for other folks joining. This person asked, do we have any idea why the federal government did this redlining in the first place, besides the obvious hate and discrimination?
Well, that's a complicated answer, and I wish I could do it quickly. You know, and I have a chapter of this on this topic in Just Action. It's chapter 2, and if you get the book, just go to that. But after the Civil War, we passed the 13th and 14th Amendments. The 13th Amendment prohibited slavery, but it had a Section 2, which authorized Congress to pass legislation to implement the 13th Amendment in a way that would abolish all the consequences of the legacies of slavery, what was called the badges and incidents of slavery. In other words, prohibiting second-class citizenship for the freed slaves. Congress passed this law in 1866. The Supreme Court prohibited its enforcement, said it was unconstitutional. In 1968, 102 years later, well, the Supreme Court's ruling was 1883, so maybe 80 or 90 years later. The Supreme Court said, whoops, we made a mistake. The 1866 law was perfectly appropriate. It was it was authorized by the 13th Amendment, and we it should have been honored. But it made no provision for remedies for the fact that for 100 years, nearly 100 years, an unequal system of segregation had been created. Well, when you have an unconstitutional system of segregation, stereotypes get created. In this new book, Just Action, I have a picture of a chain gang, a prison gang uh, of African Americans working in a field supervised by a warden with a rifle. Uh, these were people who were typically arrested in this post Civil War regime, permitted by the Supreme Court, arrested for loitering, uh, for not being able to show proof of employment when you walk down the street, for crimes that were not crimes. But many people in this country looked at these kinds of pictures, knew that African Americans, as today, have a much higher rate of uh, incarceration, and conclude that African Americans are inclined towards criminality. That's just one example of how these stereotypes get created. And so what I conclude in this chapter of Just Action is that if the 13th and 14th Amendments and the Civil War and civil rights laws that were passed, like that 1866 law, in the immediate aftermath of the Civil War, if they had been enforced and if the Supreme Court had not taken it upon itself to undo the effects of the Civil War, we would have a racially egalitarian society today. I mean, I'm sure you've heard the the kind of offensive comment made sometimes by white people that some of my best friends are Negroes. Well, there's truth to that. There's truth to that. The way to break down stereotypes is to give people contact with each other. Uh, there was a sociologist in the 1950s who demonstrated that when people have contact with others of different backgrounds, their stereotypes, their prejudices begin to disappear. But when we've had no contact with each other for 100 years, it's inevitable that all kinds of stereotypes and fears and discriminatory prejudices would develop. So I don't know how to get rid of them except to make slow progress in giving people contact with each other.
All right. So last question, and I think this is an easier one to answer, but a great question. When did Just Action come out, and is it available in any other formats other than paper print, such as audio or something similar?
Oh, sure. Yeah, it's like any trade book. Yes, it's available um, on Audible. In fact, my daughter and I read the version on Audible, so you could, if you're not already bored with hearing my voice, you could go listen to Just Action on Audible. It's also, of course, available on Kindle, uh, as well as in both a hardcover and a paperback version.
Well, thank you so much. We've got a lot of folks who want to connect, so we will try and make those connections happen. Have a great day, everyone.
Thank you.